It is 11 o'clock and we are here for Farming Today, an online agricultural conference brought to you by the St. Cloud Area Chamber of Commerce and lots of wonderful sponsors. So we do want to recognize a couple of those sponsors right now before we go into our next breakout rooms. Thank you to Steffes Group and Arnzen Construction and St. Rosa Lumber for their sponsorship. And let's hear from very briefly hear from a couple of our sponsors.
No matter how you buy ag equipment, AgDirect can finance it. We're powered by Farm Credit, people who know agriculture. So along with options to purchase, lease, or refinance, AgDirect offers attractive rates, helpful service, and ag-friendly terms. When you compare the price of iron, be sure to compare your cost of money. Ask for AgDirect. Built for agriculture, powered by Farm Credit.
AgDirect is built from the ground up to finance ag equipment exclusively. More than offering attractive rates, we offer ag-friendly financing options, experience, knowledge, and service. It's easy to understand why AgDirect is among the fastest-growing farm equipment financing brands in the nation. Whether you buy equipment from a dealer, at an auction, or a private party, choose AgDirect to finance it. AgDirect.com. Franklin Outdoor Advertising. Why choose outdoor? Continuous message. Outdoor advertising provides consistent exposure 24 hours a day, 7 days a week, 365 days a year. Lowest cost. Outdoor advertising guarantees a lower cost per thousand than any other media. While outdoor CPMs are about $1, CPMs for all other forms of media are much higher. Reach and frequency. The consistency delivered by outdoor advertising means a higher percentage of the target audience reached and a greater number of exposure opportunities as well. Flexibility. Advances in technology allow for frequent creative changes to all outdoor media formats, including posters, rotary bulletins, and permanent bulletins. Franklin Outdoor Advertising.
It's an enforceable document, meaning that it goes both ways. That somebody dealing with the financial power of attorney, the attorney in fact, is bound to the same extent as if they were dealing with the principal. The principal is the person who's giving the power of attorney. The attorney in fact is the person who's exercising the power on behalf of the principal. And likewise, it is important that you name somebody that you trust to act as your attorney in fact, because it is likewise enforceable against you. So if your attorney in fact writes out a check on your behalf, that is just as effective as if you had drafted the check yourself. So it's important that you have somebody that you trust to take those actions. Now, the other reason that it will terminate is it will terminate upon death of the principal. This is not a will substitute. So when the person dies who has given the power of attorney, the attorney in fact's power to act ceases upon death. So if we can turn to the next page. There are a few things that the power of attorney cannot do. They can't sign a will, a trust, or a beneficiary designation on behalf of the individual. So that means they can't create new testamentary documents. The power of attorney deals with finances, so it cannot be used to make medical decisions. That is covered by the healthcare directive, which we'll cover shortly. Again, it cannot be used after the principal dies, and it doesn't prevent the principal from acting. So, the person may continue to write checks, sign deeds, all of that, and it is not anything that prevents the principal from doing things on their own. The attorney, in fact, has the authority to act, but they're not the only one who has the authority. The principal retains that power to do what he or she had been doing before. So if we switch to the next page. We then switch over to the healthcare directive, which deals with medical issues. Similar to the financial power of attorney, the healthcare directive is a document that allows you to appoint an agent to make healthcare decisions for you when your attending physician determines that you can no longer communicate or make those decisions. Again, that you are incapacitated. The healthcare directive allows you to name who your healthcare provider should be. That is, who will be your doctor, what will be your clinic. They can choose where you will live. So whether that's all of those decisions are decisions that the healthcare agent can then make if you are no longer able to do that. Likewise, the healthcare agent has the power to review your medical records so that they can make decisions based upon what your medical status is. And if we switch to the next page, the other things that a healthcare directive allows the agent to do, or excuse me, that allows you to do, is it does allow you to name a guardian. Now, again, typically we want to avoid having to go with a guardianship. The healthcare agent is considered to be a less restrictive alternative. However, if there are family disputes or perhaps there are arguments about who should be the guardian, the healthcare directive will serve as a notice of who the individual intends to designate as the guardian. So, it would note that if this healthcare directive for some reason is not able to be used, this is the person that I want to be named as the guardian. And that perhaps comes about in a situation where, similar to the power of attorney, the healthcare directive does not mean that the person is automatically granted that power to act. So if the individual never goes to the doctor or anything like that, it may be that there is no individual to name who or there's no reason to invoke the healthcare directive because there's nobody who's made that determination of incapacity. And in that case, the directive at least would serve to indicate the person's decision about who they wanted to be the guardian if that guardianship comes about. The form also allows the individual to express their wishes regarding organ donation, whether they wish to donate organs, whether they don't, whether they've done so in another document. The document also allows you to express your wishes regarding the disposition of your remains. So whether or not you want to have a burial or whether or not you want to be cremated. Likewise, it can be used to note if you have made arrangements with a particular funeral home or other entity, you can note that as well, and that will provide instructions then, or it allows your healthcare agent to assist in making those dispositions. So to that extent, this is a little different than a power of attorney. The power of attorney ends upon death. The healthcare directive, in effect, ends upon death, with the exception of those limited items for making, assisting in the organ donation wishes of the principal, or likewise the wishes regarding the disposition of remains. So we can go to the next slide. How to make the healthcare directive more effective. It's important that you give copies of the healthcare directive to your family and medical providers so that they know that it exists. The same thing goes for your power of attorney, for that matter. If you create these documents and nobody knows that they're around, they're not going to do you they're not going to be of any benefit to you. Therefore, it's important that you provide copies to the individuals that you've named to act on your behalf, and likewise to your medical providers. You should talk to your family and your medical advisors about your wishes so that it's clear what you intend to have done. It's difficult after the person is incapacitated. If these conversations have not occurred, it makes it more difficult for the healthcare agent to make those determinations. Now, sometimes the forms will consider or will list what your particular wishes are in particular circumstances, but those circumstances may not exist. Some other event may have occurred, and therefore it's good to have that discussion with the family beforehand so that they know what you are looking, what your wishes are, what your thoughts are regarding your health care, if you have particular spiritual or religious beliefs, and likewise if you have particular concerns about particular types of procedures that you would not want to have done. So if we switch to the next slide, if you have particular questions, well, my contact information is provided. And we do have at least about 5 to 10 minutes here where we can answer questions now if you have any questions. So if you do, I'm open and we can respond to that. And I don't know, Laura, if I need to, do I need to check the chat for any of that or? You're on mute.
I muted myself. Like, yep. I don't see any questions in the chat just now, but don't be shy. If you have any questions, either put them in the chat or unmute yourself and go ahead and ask them. Otherwise, and you maybe touched on this a little bit, John. How do these documents compare to like the conservatorship or guardianship matters?
Well, the guardianship and conservatorship matters are court supervised, and so they are more involved. They have more structure. They have more reporting requirements. And whenever you do those proceedings, the first thing the court wants to know is if there are less restrictive alternatives available. Powers of attorney and healthcare directives would be two items that would do that. And so usually it is less expensive and easier for individuals to use that process of the power of attorney or a healthcare directive. However, there may be times when you really have no choice but to go with that, particularly if the person has lost capacity, well, then they cannot create the power of attorney or the healthcare directive. Or in situations, have been circumstances where, like I said, in a healthcare directive, if the person is suspicious of everybody and they won't go to the doctor and they won't talk to anybody about their healthcare needs and they are incapacitated, but there's no doctor to say that that's the case, then you may have to do the guardianship, even though they have a perfectly valid healthcare directive. The reason being is that they aren't allowing anybody to do it, or they are not seeking the medical care themselves that would allow it to be done.
Interesting. Thank you. Any other questions from the group? Great time to ask. Hopefully everyone had a chance to take down John's information. Otherwise, it will be available on the website shortly after the conference and for a period of time in the next month or so. Anything else, John, before we wrap up? People are being too shy today, I guess. No major questions, or you just covered everything so well?
Yeah, well, we'll go with the second one there, but no, I'm happy to have spent the time with you. Yes, if you have any questions, now the time, or otherwise there was the contact information there. You can always call me. I'm happy to talk to you.
Excellent. Well,
otherwise, we'll let people on to the rest of their day.
Thank you so much for your time, John. We really appreciate you being here, taking the time to be with us. And again, presentation will be available on the website, and have a wonderful day, everyone.
Thank you. Bye now.